The Muslim have constitutional right to manage its own affairs in the matter of religion because Waqf property belongs to Allah. Under the scheme of the Constitution of India, no person can be compelled to practice his own religion. If no person can be compelled to practice his own religion, then such persons cannot be debarred either to offer his property to God or whether he is Hindu or Muslim or any other religion. How my choice can be controlled? I can donate to Hindu Mandir. I donate to everywhere. I donate in Hindu Mandir. I donate in Muslim property. I donate in the Christian property. I donate in the Buddhist property. I donate everywhere. I donate beggars. I donate everywhere. How can you control this act? Madam, the spirit of my speech is, तू हिंदू बनेगा ना मुसलमान बनेगा, इंसान की औलाद है, इंसान बनेगा. Madam, this present bill covers importantly two areas of the Waqf. One, manage religious affairs of Waqf board. One of the arena is to manage control supervision of the religious aspects of the Muslim. Two, providing power to the state government to decide the disputes in respect of the Waqf property, including land and building. Article 26 of the Constitution of India provides that, subject to public order, morality and health, every religious denominations or any section thereof shall have the right, A, to establish and maintain institution for religious and charitable purpose, B, to manage its own affairs in matter of religion, C, to own and acquire movable and immovable property, D, to administer such property in accordance to such law. Madam, the Waqf is an institution for religious and charitable purpose. The Muslim have constitutional right to manage its own affairs in the matter of religion because Waqf property belongs to Allah. They have also the right to administer such property. The purpose of the bill is a clear breach of the right of the Muslims to perform their religion duty, to manage their religious affairs and therefore completely in violation of Article 26 of the Constitution of India. The bill hits basic structure of the Constitution. Madam, under Article 246, Sub-Article 1, the Parliament has an exclusive power to legislate a law under 7th schedule of List 1 and under Article 246, Sub-Article 3. The state is having the power, state legislature is having the power to legislate the law, exclusive power. Sir, excuse me, sir. That is to say, land comes under list 2, under entry 18 of the state lists. Lands and buildings vested in or in the possession of the state comes under entry 35 of the list 2 of the state list. In the proposed Waqf bill, the Parliament has no power to legislate any law in respect of the land and building vested in possession of the state in respect of the Waqf property, because the state is only having power to legislate such law. Therefore, the Parliament is now encroaching upon the power of the state legislation in deciding the question of the land and building of the Waqf. Thus, it is completely unconstitutional and divorces the Article 246, Sub-Article 3 of the Constitution of India. This is also hits the basic structure of the Constitution. By exercising any power under List 1 or List 3, state legislative power under List 2 cannot be encroached. There is a difference between a Waqf recognized by the Muslim law and religious endowment and recognized by Hindu law on the one hand and public charitable trust as contemplated by the English law on the other. The question has been considered by the Privy Council in VarthaBharati versus Bulsami Ayar long before. Mr. Amir Ali, who delivered the judgment of the board, observed that it is to be remembered that a trust in the sense in which the expression is used in English law, when the gift is directly to an idol or a temple, the season to complete the gift is necessarily effected by human agency. Called by whatever name, he is only the manager or custodian of the idol or the institution. In no case is the property conveyed to or vested in him. Similarly, that is a basic difference. The Honorable Minister, he was speaking about the Hindu trust. The Muslim law relating to trust differs fundamentally from the English law. Hindu trust follows the English law. Muslim law doesn't follow English law. That is a basic difference. Mr. Amir Ali said the Mohammedan law owes its origin to a rule laid down by the Prophet of Islam and means the tying up of a property in the ownership of God the Almighty and the devotion of the profits for the benefit of the human beings. As a result of the creation of a Waqf, the rights of the Waqf is extinguished and the ownership is transferred to the Almighty. It is religious. If it is religious, comes within the ambit and scope of Article 26 of the Constitution. The manager of the Waqf is the mutually the governor, superintendent, curator. But in that capacity, he has no right in the property belonging to the Waqf. The property is not vested in him and he is not a trustee in the legal sense. Therefore, there is no doubt that the Waqf to which the Act applies is essentially features different from the trust as is known to English law. In Sarabanu versus Union of India, 2017, volume 9, SCC, page 1, the Constitution bench held that any legal provision should be made with the application of known principles of law. If any decision is taken without supporting principles of rule of law, it becomes unpredictable and such a decision is antithesis of a decision taken in accordance with the rule of law. This proposed bill is just contrary to the well-settled principles of law which is established in the country by judgments have been pronounced not only by the Privy Council, by the Supreme Court of India also. Madam, the various provisions of the Waqf Amendment Bill 2024 is manifestly arbitrary and therefore cannot be passed by the Parliament itself. The Waqf system in Islamic tradition stands as a testament to the enduring values of charity, community, welfare, spiritual dedication rooted in the principles of Sadaqat Jariyah. Waqf in India, Waqf properties form the backbone of the Muslim communities, social, cultural and religious life, playing a pivotal role in maintaining their collective identity. This endowment sustains mosques, madrasas and cemeteries while providing essential resources to marginalized section of society, especially in an environment where minority communities often struggle for equitable access to public purposes. This is not there. Equality, equitable access is not there in case of the Muslim. That is the reason we are opposing. Over the years, excessive government oversight has raised concerns about the erosion of the autonomy and sanctity of Waqf, which under Islamic law is intended to function independently to serve its religious and charitable purposes. At the heart of the Waqf system administration lies the State Waqf Board while act as custodian of Waqf properties, ensuring their proper management and alignment with the purposes by Islamic law. These boards have consistently worked to protect Waqf properties from the mismanagement. Madam, the Waqf was centrally first introduced in 1953. Mr. Riju, the Honorable Minister has said, thereafter so many acts, then 1995 Act has come, Amendment 2013, now it is coming. Now by introducing clause 2, the title of the Act has been amended, Unified Waqf Management, Empowerment, Efficiency and Development. There is no rational basis to make such amendment of the title of the Act. Every Act is intended to make the Act more efficient and development purposes. As for example, The Companies Act was enacted in 1956, thereafter reenacted in 2013. The Act was brought to regulate the management, empowerment, efficiency and development of the control of the companies. The Waqf Act 1995 had various provisions for management, empowerment, efficiency and development. Therefore, the said proposed amendment to the title is wholly unwarranted. The title, which is being used nearly for 75 years, has no necessity to be amended unless the government wants to have the satisfaction that something new has been done. The proposed amendment to the Waqf Act, which includes a tacit attempt to alter or dilute the historical and religious significance of the term Waqf, is deeply concerning and warrants strong objection. The term Waqf is not merely legal or administrative level. It is a sacred concept deeply rooted in Islamic tradition and jurisprudence. Why you are taking away this? Madam,
they want to interfere in
please, please. The historical development of Waqf legislation in India, from the Bengal Waqf Act 1934, Uttar Pradesh Muslim Waqf Act 1960, the Waqf Act 1954, and the subsequent unification under the Waqf Act of 1995 has always retained the sanctity of the term. These laws, while designed to provide statutory governance, have consistently respected the essence of Waqf as a concept grounded in Islamic law. Madam, insertion of clause 2A. Insertion of clause 2A tantamount to nullify and all earlier judgments, degree and orders of any court in respect of the Waqf and the trust. This attempt is basically taking away the rights of the Muslim, which they have accrued. Any attempt to nullify the Supreme Court judgment by legislative process is illegal and unconstitutional. Clause 3 Roman 9 of the proposed bill that said various sects and subsects have been created. This attempt to create subsect without having any rational object is not a good sign for any religion, caste or creed. If the constitutional provisions empowers the parliament to create caste, subcaste or subclass, only then the parliament can do so. Like the scheduled caste created inside Hindus, but the constitutional provision does not empower the parliament under the guise of the Waqf Amendment Bill 2024, create Aga Khani Waqf, Bora Waqf, etc. The intention to legislate such kind of classification of Waqf board based on subsects, the ruling party in the government is having evil intention. If the title speaks about unification, creation of various Waqf board on the basis of subsect itself creates a de-unification between the sects and subsects of the Muslims. Madam, clause 3FA of the said proposed bill defines government organization including municipalities and panchayat and autonomous bodies of the state and central government to a part 9A of the constitution. Under the scheme of part 9A, the municipalities and the panchayats are self-government and autonomous bodies. How the properties of the self-government bodies can be treated as a government properties, madam? In a constitutional provision it has made it. By this law, panchayat and municipality has been described as a government properties. It is not a government properties, local self-government bodies. Therefore, there is a distinction. Therefore, this provision is bad. Madam, introduction of definition of the government property seems to be mischievous. Why Waqf will be allowed to define government property? This is an attempt legalize illegal occupation or Waqf property by government organizations. Another sin is there. In our JPC, we have said repeatedly, give us the data what the government has occupied the property. Nothing is there. And in Rajasthan, it is a case, is extreme cases. 80% of the property of the Rajasthan, Waqf property has been occupied by the Rajasthan government itself. Practicing Islam for at least 5 years is a precondition for making Waqf is thoroughly unreasonable. irrational and manifest arbitrary. Under the scheme of the Constitution of India, no person can be compelled to practice his own religion. If no person can be compelled to practice his own religion, then such persons cannot be debarred either to offer his property to God or whether he is Hindu or Muslim or any other religion. Practicing religion means day-to-day performance of his religious duty. In a secular democratic country like us, no one can compel to perform any religious duty. If such a provision cannot be made either in the Constitution or in any other statute, no mandatory provision can be made for practicing Islam for at least 5 years for making Waqf. Even if I discharge my religious duty on my own at any place, I cannot be compelled to speak whether I am performing religious duty or not performing the same. Who is anyone can ask me whether I am performing religious duty or non-religious duty? Is it not a violation of a constitutional right? What the Constitution has given you the power to say, to ask me the question, I am discharging religious duty or not discharging the religious duty? A man can believe in performance of religious duty at any point of time of his life, any point of time, before death even. Performing of a religious duty cannot be the basis belonging to that religion. Even in a Hindu mandir which is governed by an act, like Puri Jagannath Temple or Kashi Vishwanath Temple, there is no such provision that any person practicing Hindu for at least 5 years and then only can donate anything to the deity. Madam, I can't donate. If I want to donate, it's my choice. How my choice can be controlled? I can donate to Hindu mandir. I donate to everywhere. I donate in Hindu mandir. I donate in Muslim property. I donate in the Christian property. I donate in the Buddhist property. I donate everywhere. I donate beggars. I donate everywhere. How can you control this act? How can I control? By reason of insertion of this clause, no other person of a religion can make over any property to Waqf. The proposed amendment is thoroughly misconceived, arbitrary, irrational, and therefore violates Article 14 of the Constitution of India. Under Clause 3, Roman 9b, existing Clause 3R1 has been omitted. That means Waqf by user is being taken away. Waqf by user is a long-standing practice of Muslims. In our country, Waqf by user is a very common practice, and decades after decades, rather time immemorial. Waqf by user is a practice. The concept of Waqf by user was recognized in our country in the case of courts of words for the property of Magdam Hassan Baksa versus Illahi Baksa and others. 1912, SCC online, page 45. Madam, the Honorable Apex Court in the matter of Sayyid Muhammad Salih Labbai, dead by Eller and others versus Muhammad Hanifa versus Eller and others, 1976, 4 SCC 780. In paragraph 34, 36 and paragraph 39, categorically accepted this Waqf by user. The necessity is necessary in case of prayers offered in congregation. A single Muslim can also offer his prayers with or without an imam, but if prayer is in a congregation of a Jannat are offered only behind an imam who leads the prayers. And Islam is an extremely modern and liberal religion. There is no question of any person being denied admission in a mosque for the purpose of offering prayers. And that is why the law is so strict that the moment a person is allowed to offer his prayers in a mosque, the mosque becomes dedicated to the public and therefore it's a Waqf property.